I sat in a courtroom hallway and listened to my husband's attorney read my own words back to me. Words I had only ever said inside a locked office, to a therapist, with the door closed and a white noise machine humming outside it. Word for word, almost. Enough to make my stomach drop through the floor before I even understood how it was possible. My name is Nina Doyle. I'm 36, mother to a 6-year-old named Theo, and until 11 weeks ago, married to a man named Marcus who I genuinely believed I knew. We separated after I finally admitted, to myself and then to him, that I'd been unhappy for years in a marriage that looked fine from the outside and felt like slowly disappearing from the inside. I started therapy 2 months before I ever mentioned divorce out loud. Dr. Alana Rhea's office became the one place I said things I couldn't say anywhere else. Fears about whether I was a good enough mother, resentments I was ashamed of, half-formed thoughts about my own worth that I needed to say into a quiet room before I could believe them myself. Custody mediation was supposed to be routine. Instead, Marcus's attorney, a sharp, unbothered man named Vance Whitfield, stood up and calmly described concerning patterns of emotional instability documented in Mrs. Doyle's own words, before quoting, almost verbatim, a sentence I remembered saying only once, in Dr. Rhea's office, about feeling like I sometimes resented motherhood on my hardest days. I turned to my attorney, my whole body cold. I never said that to anyone but my therapist. She looked as confused as I felt. Then how does opposing counsel have it? I didn't have an answer. I sat there, replaying every session I'd had in that quiet, locked room, trying to understand how a sentence I'd whispered to one person, in one private hour, had somehow made its way into a legal filing designed to take my son away from me. I had no idea, sitting frozen in that hearing, that the answer was sitting in my own living room the entire time, small, gray, unassuming, and listening far more than I ever imagined. I didn't sleep that night, running the timeline over and over. Dr. Rhea's office had no windows facing the street, no recording devices of any kind. I'd asked, early on, paranoid in the ordinary way new therapy patients sometimes are. She'd shown me herself. Nothing. Which meant the leak wasn't happening in that room. It was happening somewhere else, closer to home, in a place I'd never once thought to be careful. I called Dr. Reyes the next morning, hands shaking. Is there any way at all, that something I said in your office could end up in someone else's hands? Not from my end, she said carefully. But Nina, do you do your sessions in person or over video sometimes? Sometimes video. When Theo's sick or the roads are bad. From where in your house? My home office, I said slowly. Right next to the kitchen. Right next to the kitchen, where 8 months ago, Marcus had proudly installed a Vesper Home smart speaker on the counter. Voice activated, always listening for its wake word, controlling the lights, the thermostat, the music, the small conveniences of a life I'd thought was ordinary and safe. I stood in my kitchen that evening staring at the small gray device like it was something venomous. I remembered, with a sick lurch, Marcus joking once, early in our marriage, half proud and half oblivious to how it sounded, "This thing hears everything in this house. I love it." I unplugged it with hands that wouldn't quite stop shaking, and sat down at the kitchen table where I used to feel safe, trying to figure out exactly how much of my private life this small gray object might have quietly been handing over to the man I was divorcing. I brought the device to my attorney, Denise Okoro, the next morning, along with the exact date and time of the mediation hearing where my private words had somehow surfaced. "If what you're describing is accurate," Denise said, turning the speaker over carefully in her hands, "this isn't just an invasion of privacy. Depending on how it was accessed, we could be looking at illegal wiretapping. But we need proof it was deliberate, not some accidental setting neither of you understood." She referred me to a digital forensic specialist, a quiet, methodical man named Preston Adeyemi, who spent 2 hours examining the device and Marcus's linked account activity before he finally looked up from his laptop. "This device has remote access enabled," Preston said. Someone with the account credentials can activate the microphone from anywhere, listen live, or set it to record specific windows of time. I can't access the manufacturer's full server logs without a subpoena, but the local device history shows activation patterns. Can you tell what days? What times? He turned his screen toward me. A list of dates stretched back 4 months, every single one falling on a Thursday, between 4 and 5 in the afternoon. My therapy sessions were every Thursday, 4 to 5. I stared at that list until the dates blurred together, a cold, sick certainty settling into my chest that this wasn't an accident, wasn't some overlooked setting, wasn't anything except exactly what it looked like. Someone, deliberately, week after week, turning on a microphone in my own home to listen to the most private hour of my life. Nina, Preston said gently, I need to ask. Who else has access to this account? I already knew the answer before he finished the question. I confronted Marcus that weekend, during a custody exchange in a parking lot neither of us had chosen for privacy, Theo's car seat still visible in the back seat of my car behind me. You've been listening to my therapy sessions, I said, no preamble, nothing softened. Every Thursday. For 4 months. Something flickered across his face. Not shock, I registered slowly. Recognition, quickly smoothed over into practiced concern. Nina, I think you're not thinking clearly right now. The divorce is stressful, I understand that, but accusing me of something like this. I have the activation logs, Marcus. Every Thursday. 4 to 5. Don't. His jaw tightened. For a moment, the performance cracked entirely. Vance said we needed documentation. Real documentation, not just my word, if we wanted a fair custody outcome. He said parents record things all the time now for exactly this reason. Your attorney told you to secretly record my therapy sessions. He said it was a gray area. Smart home devices in a shared account, in a house we both technically still owned at the time. He said the law wasn't as clear as I assumed you'd think it was. I stood there in that parking lot, humiliation and fury tangled together so tightly I could barely separate them, not just at what had been taken from me, but at how deliberately, how confidently, an entire legal strategy had apparently been built around exploiting the one place I'd believed was completely mine. Get back in your car, Marcus, I said quietly. You'll hear from my attorney. I drove home that night with Theo asleep in the back seat, replaying every session I'd had in that 4-month window, every fear, every private admission, every fragile, half-formed thought I'd trusted to one closed office, now sitting somewhere on a server, available to a man building a legal case to take my son away from me. Denise filed an emergency motion within days, requesting the device manufacturer release full server-side activation logs under subpoena, along with a motion to exclude any evidence derived from the recordings on grounds of illegal interception. Vance Whitfield's response was swift, and precisely as condescending as I'd expected. In his written opposition, he argued that shared home devices carried no reasonable expectation of privacy between spouses still legally married at the time of recording, and suggested, in language clearly meant for the judge, but that landed on me like another small, deliberate cut, that my heightened emotional reaction to ordinary household technology was itself relevant to the custody evaluation he was requesting. I sat in Denise's office reading that filing twice, my hands cold. He wasn't just defending the recordings. He was using my justified fury at being secretly recorded as fresh evidence of the exact instability he'd already tried to manufacture for my therapy sessions in the first place. This is a pattern, Denise said grimly, sliding the filing back across her desk. I've seen Whitfield's name before, Nina. Different case, a few years back. Similar language, almost identical strategy. Undermine the mother's emotional state using anything available, then frame her objections to it as further proof. Do you remember the client's name? Denise pulled up an old case file, scrolling for a long moment before she found it. Bridget Callahan. Contested custody case. 4 years ago. I wasn't her attorney, but I remember the outcome. She lost primary custody, partly on the strength of a psychological evaluation Whitfield pushed hard for, built on some fairly aggressive digital evidence gathering no one ever fully explained in the ruling. Something cold slid down my spine. I need to talk to her, I said. If this happened before, I need to know exactly how. Bridget Callahan agreed to meet me at a coffee shop 2 towns over, cautious at first, guarded in the specific way I recognized instantly from my own last several weeks. He used my email, she said quietly, once I'd explained why I'd reached out. My ex had access to my personal email during our marriage, still logged in on a shared computer months after we separated. Vance Whitfield told him it was fine to keep using it as long as they were technically still married, same argument he's apparently using with your smart speaker. Did you ever find out how long he'd been reading it? Almost a year, Bridget said, voice tight. Messages to my sister about how overwhelmed I felt some days. A few private conversations with a friend about wanting space, needing time to myself sometimes, the ordinary things every exhausted parent thinks in their weakest moments. He built an entire custody argument out of my most human, most private complaints. And the outcome? I lost primary custody. I still don't have it back, 4 years later. By the time I understood what had actually happened, the psychological evaluation was already filed, already shaping how every judge since has read my case. I sat across from her, grief and fury tangling together in a way that had nothing to do with my own situation anymore, and everything to do with the pattern quietly revealing itself between us, 2 women, for years apart, targeted by the same calculated strategy, the same attorney, the same exploitation of exactly the private spaces where we'd once felt safest. I have proof, I told her. Server logs, forensic analysis, a documented pattern of remote activation timed precisely to my therapy sessions. If you're willing, I think we might finally be able to show a court what actually happened to both of us. Bridget's hands tightened around her coffee cup. It's 4 years too late for me. But if it stops him from doing this to the next woman, yes. I'm willing. Denise moved fast once Bridget's case entered the picture, filing an expanded motion that framed the smart speaker recordings not as an isolated incident, but as part of a documented strategy Vance Whitfield had apparently employed at least twice, using different technology, the same underlying tactic: exploit a spouse's most private communications, then weaponize their justified distress as further evidence against them. The subpoenaed server logs from Vesper Homes' manufacturer arrived 12 days later, and they told a story more damning than even Preston's local device analysis had suggested. Every single activation aligned precisely with my scheduled therapy sessions, not random household use, not an accidental setting, but a specific recurring command issued remotely from Marcus's separate account, timed deliberately to a 55-minute window that matched Dr. Rhea's calendar exactly. This isn't a gray area anymore, Denise said, reviewing the report with visible satisfaction. This is premeditated. Someone researched your schedule and built a surveillance pattern around it. The judge overseeing our custody case ordered an emergency hearing once the full evidence package was filed: Preston's forensic analysis, the manufacturer's server logs, Bridget's sworn statement about the near-identical pattern in her own case 4 years earlier. Vance Whitfield's composure, so carefully maintained through every prior filing, finally cracked slightly under direct questioning, his usual smooth confidence replaced by something closer to controlled damage assessment. My client believed, in good faith, that shared home technology fell within reasonable marital access, he argued, though even his own voice seemed to have lost some of its earlier certainty. Your client, the judge said flatly, reviewing the timestamp comparison between activation logs and therapy appointments, apparently believed good faith meant scheduling illegal surveillance around his wife's therapy calendar with enough precision to suggest premeditation rather than confusion. I'm inclined to disagree with your characterization, Mr. Whitfield. The recordings were ruled inadmissible in their entirety, not just excluded from evidence, but formally struck from the custody evaluation that had been partially built around them, with the judge ordering a full re-evaluation using only legitimately gathered information going forward. More significantly, the judge referred the matter to the State Bar Association for review of Whitfield's conduct, specifically the documented pattern between my case and Bridget's, and opened a separate line of inquiry into whether the recordings themselves constituted a criminal wiretapping violation independent of the custody proceedings entirely. Marcus, facing potential criminal exposure of his own, dropped his aggressive custody demands within a week, agreeing through new counsel to a standard shared custody arrangement neither of us had to fight over anymore. I don't know if that was strategy, guilt, or simple self-preservation once his own attorney's tactics became a liability instead of an advantage. I stopped trying to guess at his motivations somewhere around the third week of this process. It stopped feeling like it mattered. Bridget's case, reopened based on the newly established pattern, moved slower. 4-year-old custody arrangements aren't easily undone, her attorney warned her, even with fresh evidence of how unfairly the original evaluation had been influenced. But a formal modification hearing was granted, something she told me, quietly, over the phone, she'd stopped believing was possible after 4 years of being told the door was closed. "You did more in 6 weeks," she said, "than I managed in 4 years alone. You're the reason any of this had a pattern to prove," I told her. "I just had the version of this that happened to you, 4 years too late to help you the first time, but early enough to actually do something with it." I sat across from Dr. Reyes 3 weeks later, in the same small office where I'd said all the things that eventually ended up quoted back to me in a courtroom, and cried for the first time since this entire nightmare started. Not from grief exactly, but from something closer to the specific relief of feeling safe inside that room again. "I keep thinking about everything I said in here," I told her, "wondering how much of it I'll ever be able to say freely again, without some part of me calculating how it might sound in a legal filing someday." "That instinct will fade," she said gently. "It's a reasonable response to something that genuinely violated you. It doesn't mean this room stops being safe. It means you'll need some time to trust that again." I thought about Bridget, 4 years into rebuilding that same trust, still fighting for a version of justice that arrived too late to undo the original damage, but early enough, finally, to matter going forward. I thought about how many other women might be sitting in similarly private rooms right now, saying similarly private things, with no idea a small gray device somewhere in their own home was quietly listening on someone else's schedule. The State Bar's investigation into Whitfield expanded over the following months, uncovering 2 additional cases with variations on the same pattern, different technology each time, the same underlying strategy, the same exploitation of exactly the spaces his client's spouses believed were safest. His license was suspended pending a full hearing, and both additional affected women were connected with attorneys willing to explore reopening their own cases. I didn't do any of this planning to become part of some larger pattern of exposure. I did it because I refused to let a courtroom decide my fitness as a mother based on words I'd only ever meant to say to one trusted person, in one locked room, on one ordinary Thursday afternoon. It's been 8 months now. Theo and I share custody with Marcus on a schedule that finally has nothing to do with manufactured evidence or exploited vulnerability, just an ordinary, workable arrangement between 2 parents trying to raise their son as decently as they can manage, separately, after everything. I replaced the smart speaker with nothing at all. My kitchen is quieter now in a way I notice most on ordinary Thursday afternoons, when I used to feel, without quite understanding why, a small flicker of unease I'd talked myself out of every single week. Bridget's modification hearing is still moving through the court, slower than either of us would like, but moving. We talk most weeks now, an unlikely friendship built out of the specific narrow overlap of what one man's legal strategy did to both of us, for years apart. She sent me a message last month that I've read more times than I probably should admit. "You believed me before you even had proof. That mattered more than you know." Vance Whitfield's disciplinary hearing is scheduled for next spring. I plan to attend, not for closure exactly, I'm not sure this particular kind of violation ever fully closes, but because Bridget asked if I would, and because showing up for each other has become the one part of this entire ordeal that actually felt like it repaired something instead of just documenting what broke. Dr. Reyes' office still doesn't have windows facing the street. It still doesn't need them. What changed is smaller, quieter than that, the specific hard-won knowledge that safety isn't really about the room at all. It's about who you can actually trust not to weaponize what you say inside it. I think often about the version of myself who almost didn't notice, who might have chalked up that first quoted sentence in the mediation hearing to some strange coincidence, some overlap of language, rather than following the thread all the way back to a small gray device quietly listening in my own kitchen. I think about how easily that version of this story ends with Marcus winning primary custody on the strength of my own private words, twisted into evidence I never consented to give. What I know now, that I wish someone had told me before any of this started, is that privacy inside your own home isn't guaranteed just because the walls are yours. Somewhere between convenience and surveillance, a lot of ordinary technology quietly blurs a line most of us never think to question until it's already been crossed. Bridget spent 4 years believing she'd simply been an unfit mother in some vague, unprovable way a judge once decided was true. I spent 11 weeks nearly walking the exact same path, saved only by a strange coincidence of paying close enough attention to a single quoted sentence to start pulling the thread. If you discovered that your most private words, the ones you only ever said in one locked, trusted room, had been secretly recorded and used against you, would you have caught it as quickly as I did, or would you still be sitting inside a version of this story you didn't even know had already started? If Nina's story moved you, don't forget to subscribe for more real emotional journeys like